Examination of the complaint. May I read paragraph 32? Paragraph 32. 32 of the judgment
Hmm.
from
You have read.
2018, volume 7, Supreme Court case.
You want to say anything, Mr. Das?
No, man. Only one animal or para 37 in the judgment,
37 of which judgment?
2018, 7 SCC.
Yes.
Last 37, last line. Last line, we make it clear that. We make it clear that our observation is made and above the facts of the present case. This is not in general. Facts is
The fact you have admitted that yes, the inquiry officer has cross-examined. Inquiry officer has examined as well as cross-examined. Now, he could have left it at that stage. He went forward and he analyzed the evidence. And then he recommended a punishment. Kindly come to page 37. তাহলে আর হলো না। Now the person has retired also.
And my lord, but may I please go, my lord, one quoted say, the appeal court,
No, no, don't multiply judgments. What you want to show?
no, my lord, I am only drawing my lord's kind attention to paragraph 4 of the judgment reported in 1975, where the Supreme Court has said the appeal court interferes, where the judgment under attack is not right, but when it is wholly wrong. It is in paragraph 4 of the judgment reported in PIR 1975.
Krishna,
Paragraph 4.
Krishna, His Lordship Krishna. Will not interfere when it is not when it is wrong. It is clearly wrong. Paragraph 4. The court of appeal
There is a
not make
prudent
the judgment
condition for which
right, but the present appeal. The present appeal. The present appeal.
I apologize to your lordship for mentioning item number 2, which was adjourned till 2nd of May. I forgot to bring it to your lordship notice that the interim order is till 30th of April in that matter. Lordship has been pleased to direct the matter to appear on 2nd of May.
কোনো order করেছিলেন?
I am mentioning upon notice, your lordship.
He has joined.
No, he has not joined.
You give a ring to him and ask him to join.
Lordship kindly directs the matter to appear to be mentioned tomorrow. I shall inform Mr. Pal.
If he can join, very good.
I tried.
Ask him at 2 p.m. if he can join.
He's not here in physically, but he will not be able to join today. So, Lordship kindly directs the matter.
He's junior. Any junior?
No, Lordship, he is appearing. I don't find any
তাহলে
juniors.
ফাইলটা দিও।
I apologize because it completely went out of my mind that the interim order is due to
So
expire.
we
on
come back at 2 p.m. You give him a ring
Thursday.
that the court wants him to be on. অনলাইনে এসছে তো ওই ফাইলটা একটু বাড়াবে
Informed him, said that.
ফাইলটা দাও একটু
My lord, I am appearing on behalf of Anjan Paul.
Acha, he is
I am appearing on behalf of Advocate Anjan.
Yes, we kept it on second, but the interim order is going to expire, so we will be extending that. ওই ফাইলটা দাও চলে গেছে নাকি
Sixth February order.
ও ওই অ্যাপিয়ারিং অনলাইন করে দিও হ্যাঁ ওই পাল
On your part.
February order.
হার্ড মিস্টার মজুমদার and advocate the judgment যেই নাম কি
Lordship, in item number 18, I'm for the appellant, and
Other appeal, I am for the appellant.
the connected appeal is by my learned friend.
Item number
18 and 19
fixed হয়ে রয়েছে
at 2 p.m. Because you're sorry, 19 and 20. Sorry.
19.
Lordship had heard this matter at length. This was about expunging a particular statement about misappropriation, which was my submission that there has been no misappropriation.
So
but-
you argue when it was hard.
Okay. So,
Finish it off.
yes, yes.
Finish it off today.
Okay, my lord.
The
Or
two
my
appeals-
learned senior friend continue, I will come back any other day, my
No, no. Oh, we will stop him. He will finish it. We cannot give so much of time.
Then should I place my submission? My submission will be very short, my lord.
Wait and make your submission. Let me. Yes, yes. Fast.
Yes.
Just
Yes. I'll just reiterate.
গুলি দিয়ে
Lo-
দেবো। চারটে আর পারলো না আর কয়েকটা করে দিও।
With this lordship, I had taken out a modification application. With this appeal, it is still pending. That is the main crux of the matter. It is for striking down certain strictures as reflected in particular paragraphs of.
No,
The
what
on-
is the number of your modification application?
Yes.
Have you annexed that in the paper book?
Yes, it is part of.
So you are appearing for Rajat Kumar Vats.
Yes, yes, lordship.
You are the bank.
I am for the bank.
Lordship, may I just place the facts in brief first? Lordship, there were 2 allegations against me.
কার্তিক ওখানে এভিডেন্স সার্ভিস থাকবে দেখো ওটা কি? ছেড়ে দাও এদিক করে।
One page to background. Modification. Pages 572, 573.
You are in which appeal? FMA?
The first one is,
You are in which appeal? Both are preferred by you.
no. The first one is by me, the second is by the bank.
আচ্ছা FMA 327 is of yours.
Yes, Lordship.
And FMA 320,
2024 is Mr. Chakraborty. And Mr. Bormon. Mr. Bormon.
one word.
So Mr. Chakraborty, you place the order in
Yes,
the facts will come.
yes, yes.
Longish order or short?
No, my lord, not much. The facts are more or less admitted, my lord. The
But,
learned senior is
আচ্ছা, আচ্ছা,
Let me finish.
বসো না বসো।
Lordship will kindly come to page 555.
বসে রয়েছো আরামে তো আমাদের তুলে
But that is the 555 is the operative part of the judgment, but then I have to place the,
555
that is paper book 4.
4 নম্বর।
The crux of the matter
Yes.
by which I'm aggrieved, that is in page 555. Because I have only come for expunging of a particular comment. Otherwise, it is in my favor,
ও আচ্ছা
the judgment. If your lordship recalls, this was about misappropriation.
পেজ 555
555 and it goes on till 557.
was 557 is another order of
No, no, actually, while the judgment was being delivered, I sought certain clarifications. So my lord incorporated them in the order, in the judgment.
Very good. Which judgment starts from page 336.
Yes, but
You are showing us.
if I show this, your lordship will get a grasp of what
Yes,
happened.
yes.
That is why. Later on, if necessary, I'll go back.
36. Dated. Yes, tell us.
Yes. First, may I just state the facts in brief, then it would be easier. Lordship, what happened was this gentleman was the branch manager of Central Bank of India, situated at Rajarhat. Rajarhat not here, but in North Bengal, Jalpaiguri district. Now, this gentleman was dispersing loans to various people and associations.
You are the manager.
Yes, branch manager.
Hmm.
Under Swami Vivekananda Shonirbor Prokolpo Jojon. Loans were being disbursed to persons who wanted to start their own business.
Hmm.
Now, in this particular case, what happened was that two people applied for a loan, and in order that they may get the requisite goods from the supplier. Now, normally there's a bank procedure by which it has to be channelized. This man, the supplier, Mr. Nareri, he was Mr. Nareri. He was the supplier. There's an affidavit which I'll show later.
Who are the loan applicants?
Yes, two applicants.
Two loan applicants.
Loan applicants.
What are their names?
Yes. Just a minute, Lordship.
Then what happened?
Yes. Now, this, because it's centers around Mr. Nareri. Mr. Nareri said that this is a long, cumbersome process. So why don't you give us in cash? So he resisted that this is not possible. I cannot give it in cash. It has to come through the routine process. Due to severe insistence from time to time, what happened was that this man's wife, who is an entrepreneur in her own right, she's a businesswoman, she disbursed rupees 25,000. That was the amount required.
Your wife?
Yes. She disbursed rupees 25,000 to this person, to this supplier. And after that, this 25,000 was reimbursed from the bank to
Your wife.
Yes. But since a proper, this
25,000 your wife transferred from her account in the bank.
She gave it in cash. She gave it in cash. And it was on the same day. There was no question of any misappropriation. On the same day. First, she gives the money, and then the bank reimburses her.
Now, how does the bank reimburse? That is going through
the account.
Account of
So, yes.
your wife.
So, since that was not the proper procedure, I admit that was not the proper procedure. So that is why when the learned trial court judge inflicted a minor penalty, it is here on the very next page, he inflicted a minor penalty. So your lordship had previously asked me that you have not challenged this.
What is the minor penalty?
Yes, lordship comes to page.
No, tell us now. What is
yes,
the
yes.
withholding of increments?
Yes, I'm reading it out. The respondent number 1 bank and its disciplinary authority is hereby directed to impose the minor penalty of reduction to a lower stage in the time scale of pay.
Very good. Then what happened?
Now, this is what happened.
You accepted this penalty.
Because it was an irregular procedure. I admit it was an irregular procedure, but it was not misappropriation.
Very good. Accepted.
Yes. So I accept it, but lordship kindly sees the safeguards that my lord has given. This is in page 556 onwards. May I just place it? The respondent number 1 bank and its disciplinary authority is hereby directed to impose that penalty. Then on the very next page, he says, judgment as printed in separate sheet is pronounced in open court and the same be kept in file. In view of the disposal of the instant writ petition, the respondent bank is hereby directed to reinstate the present writ petitioner in his service after imposition of mine. This is page 557. 557. Yes.
The judgment was
from 536 onwards.
the oral judgment.
Because
saying
the
that the longest judgment is
Lordship, when the judgment was being delivered,
uh,
I had raised these clarifications. So my Lord said that I'm incorporating this.
wise.
So-
Reinstated in service after the imposition of minor when paragraphs pass and the period of suspension of the date from which he was dismissed shall have been reckoned in service and they have presented to all service including pension. Very good. You have retired?
No, I was just 30. I was terminated for this.
No, now.
I'm now 38 around.
You have not retired.
For 10 years, I'm under dismissal for this. Now, Lordship comes to page 557.
Yes.
In view of the disposal of the instant writ petition, the respondent bank is hereby directed to reinstate the present writ petitioner in his service after imposition of minor penalty as mentioned in paragraph number 27 of the judgment as passed today, and the period of suspension as well as the date from which he was dismissed from his service shall have to be reckoned as in service. And therefore, the present writ petitioner is entitled to get all the service benefits, including the pensionary benefits. It is further directed that the present writ petitioner shall have to be reinstated within a period of 1 month from the date of communication of the judgment as passed today in open court, and the instant order is also passed in open court. Lordship, so basically this is...
So you joined.
No, they came up with this appeal and there was a stay order, so nothing moved. So now it is another 2 years since the delivery of this judgment.
Very good. Proceed.
Yes,
Then
yes.
what is the problem?
So yes. So now what happened was, so when this money was transferred from my wife.
Which remark you want expansion?
Yes. May I place them? They are in the modification application. Kindly takes up page 572 to 573. Modification application.
Modification of the
Justice sends order to the extent that...
now what happened to that modification application?
No, it's still pending. It is part of the paper book. It was not taken
before
up.
us.
Yes. Page 57, because that is the matter. There's nothing else in this matter.
You did not prefer any formal appeal.
I preferred appeal only on this point, that these words have to be struck down because they are prejudicial to me.
Where are the words in the
Yes,
judgment?
yes, in the judgment. Yes, Lordship. It starts from para 30.
So you ought to have filed that application before the single judge.
No,
Why
because,
you are filing in
because
appeal?
Lordship, my appeal was only on that point.
Which point? That incorporation of these remarks.
That expunging of these remarks.
Where is that remark?
Yes. It starts from para 13, 14, 15, and 25 of the judgment. So I'll place the judgment. Paras 13, 14, 15. I'll place the page. 543, Lordship. 543. But before coming to this, there is a bank entry. My learned friend's bank had made an entry as to when the...
Upon reading
Yes, so-
this, we will come to learn what is your problem. Place paragraphs.
It starts 13, 14, 15.
Place.
Yes. Keeping in mind the above principles of law as enunciated in the reported decisions of High Court of Judicature at Bombay Supra, if the factual and circumstantial aspects is involved in the instant lists are considered, it would reveal that practically there is no scope for this court to interfere with the concurrent factual findings of fact in respect of charge number 1 as against the present writ petition. It appears to this court, all the three authorities of the respondent bank have come to concurrent findings that a sum of rupees 25,000 was credited to the account of the wife of the delinquent by debiting the same from the internal account of the bank, which tantamounts to misappropriation of fund. Now, this did not happen.
To the account of the wife by
This did not happen. Next, the argument of the learned advocate for the writ petitioner that in absence of any proof of benefit, either of the writ petitioner or of his wife, the writ petitioner cannot be held guilty of the charge number 1 does not seem to be convincing, since credit of an unaccounted sum in a person's account itself is a benefit for that very person, unless contrary is proved by the said person himself. Here, I am in a position to prove the contrary. I have given the evidence. which I will place.
Credit of an unaccounted sum in a person's account itself is a benefit.
Now, here, Lordship, I am in a position to prove the contrary. In view of the discussions made herein above, this court thus finds no reason to interfere with the findings of the disciplinary authority and the appellate authority with regard to charge number 1, and those are hereby affirmed. And then, Lordship, there's para 25. Para 25 is on page 553. 553.
553. Paragraph 15.
Para 25. Oh, sorry, 555. That is the para which I had placed at the time of the
Yes.
judgment. Now, Lordship, as my Lord says, that unless proved by the petitioner himself, now there is evidence to prove that I was not guilty. So may I just place that? Which was there. It was also.
What was charge 1 was found to be proved. Though according to you, there is enough substance to show that charge 1 cannot be proved. But that is not the subject matter of appeal here.
No, but
Your subject matter of appeal is the remark. Show us those remarks.
these are the remarks, nothing else. These are the remarks which are prejudicial to me because I have not committed misappropriation.
But you have not challenged the charge.
Lordship,
You have not challenged the charge.
Lordship, I have not challenged that minor penalty because from the very beginning, the stand has been that this has been a technical irregularity from the very beginning. Even before I came in, Lordship, this is a change brief. Even previously, the stand was taken. Mr. Kishore Datta was there. Even then, the stand was taken that this is a technical violation, but there is no misappropriation.
If the charge is not challenged, on the basis of that charge, you have been imposed a punishment.
That I have agreed to, but
Let us complete. So, in establishment of a charge 1, your punishment has been given, you have accepted that. Now you are saying, I have no problem with the punishment, but now I have problem with the remarks made in the charge. That is your condition.
no, may I modify? The punishment was in relation, so-called punishment, this minor penalty. This was in relation to a technical violation. Now, I cannot improve on the situation. There was a technical violation, but that technical violation is not misappropriation. That is where I'm prejudiced. Because if there's a technical violation, very well, I admit to a minor penalty. But how is it misappropriation? I have enough evidence to show that
Where
it is
is
not.
the show us charge 1?
Yes. Now, Lordship, may I take your Lordship through the departmental inquiry where it was taken up?
Let us understand where is your charge. Charge is misappropriation. Charge against you is misappropriation.
Yes, I'll show the charges. But then I have to go to the charge sheet.
কোন findingটা হতে হবে? Does not seem to be convincing.
One,
It
two,
seems
three.
credit of an unaccounted person is itself is a benefit from the person.
Which tantamounts to misappropriation of fund.
Kindly,
Come to a concurrent finding. এটাকে অল্টার করে বলে দাও ইট ওয়াজ এ
Charge to the misappropriation of fund. Charge has been বলছে proof. So, quantumটার জন্য কমিয়ে প্যারাগ্রাফ 25 Excellent paragraph. However, considering the fact the amount of misappropriation is not left to observe a minor point. Charge to the proof.
জিজ্ঞেস করুন তো
Where's the charge sheet? Let us
Yes,
see the
page
charge number.
120. Page 120, volume 1. Now, charge 2 and
কি আমি বোঝাতে পারছি না।
Against the misappropriation.
কি আমি আগের দিন চেষ্টা করি। Yes,
charge number 1 was pressed and charge number 4. 2 and 3 were not pressed. So there were just two charges, 1 and 4. And in 4, the charge 4 was quashed. Totally quashed.
and 1 and 2, 2 and 3 were not
But
taken
not
up.
even pressed. They
Not really.
themselves said that there is no offense involved. Charge 1 on
Mr. Chakraborty, charge 1 says he deliberately allowed misappropriation of bank's funds for benefiting his family member. That's the charge. Charge 1 has been proved. According to now, because charge 1 has been proved, you've been foisted with a penalty. The learned single judge has held because the amount is a trivial amount of 25,000. He's reduced it to a minor punishment which you've accepted. If you've accepted it, whether it's a minor punishment or not, once you accept it, are you not accepting the charge as framed?
may I submit? There is a specific schedule where minor charges and major charges are set out. Now, according to that, if a person is terminated from service, it is a very major charge, and the penalty which is there in a minor charge cannot be invoked in case of a major charge. Now, whether the amount is 25,000 or whether the amount is 25 lakhs, I was terminated from service. Now, my Lord has given me back everything. Now, if it is misappropriation, I could not have come back. I would have remained terminated.
That was their wisdom, Mr. Chakraborty.
No, but this is the paradox, Lordship.
My brother has put a question to you in respect
I
of charge
understand.
1. So then how can you
But
turn
then,
back? How can you turn back and challenge the expansion of the remark of misappropriation?
but Lordship, I am again repeating that there has been a technical irregularity.
We will record that, which will not begin. The observations which we make, that will be there. If we hold against them, if we do not allow their appeal, we will explain this in this manner, which
now-
will serve your purpose.
Now, may I just elaborate on this?
Not
Because
required,
because
you
an
are-
affidavit has been filed by Mr. Nareri.
Mr. First, you cross the hurdle of which my brother has.
Yes, yes. So my submission is this, Lordship, that if there are certain charges which are enumerated in disciplinary proceedings in the handbook of disciplinary proceedings, every charge has with it a particular punishment. Now, be it 25,000 or be it 25 lakhs, if it is misappropriation, the punishment is that I am terminated from service. Now, that has not happened.
Mr. Chakraborty, if you are trying to say that the reduction of the punishment by the learned judge should be an automatic reversal of the charge, that we can't hold.
I'm not saying that. I'm only saying that I cannot escape a minor penalty because there has been a technical violation. But
That's not the finding of the learned judge. You are
Lordship-
seeking expansion of a particular
Lordship-
comment.
Lordship, may I say this? First, the inquiry authority cleared me. It is there on record. The inquiry authority only said, yes, factually, the amount has gone into his wife's account, factually. But there is no misappropriation. This is the inquiry authority said. Now, the disciplinary authority and appellate authority said, there's no connection with this 25,000 which has gone to the supplier. So we say that there has been misappropriation. Now, here,
So we say that there is no misappropriation.
that is the inquiry authority. Inquiry authority said the amount has gone. That is true. But there has not been any misappropriation.
Show us that page.
Yes, yes. The kindly তার আগে ওর ইয়েটা ফাইন্ডিংটা দাও পেজ 389 লর্ডশিপ page 389
389.
yes
Yes.
there lordship comes to charge number 1. This is what the disciplinary authority says, but prior to that let me place the inquiry authority's report. The inquiry authority will এটা তো ভুল দিলে ওটা তো disciplinary authority. Lordship comes to page 365. Inquiry authority down now to disciplinary.
365 is written argument.
This is
This is your letter to the authority, KP Raju. Like it. Now, this is the inquiry report.
just 1 minute.
Written argument for the conclusion.
Kindly give me 1 minute.
76.
365, 376.
Findings of the inquiry.
Findings of the inquiry, page 376.
Sorry. Here, kindly see the last paragraph. I hold the observation that charge on 1/1/2015, the internal account such and such was debited by 25,000 and the amount was credited to savings account number of Shikha Varshni, wife of Rajat Kumar Varshni. Shikha Varshni withdrew out of this fund is proved, and Mr. Varshni deliberately allowed misappropriation of bank's fund for benefiting his family member is not proved. So the charge is partially proved. He says the amount went there, but it was not for the benefit of his family member. After this lordship, after this happened, the disciplinary authority and appellate authority held otherwise. Now, in the trial court decision, the learned judge himself has, yes, Justice Sen has himself passed strictures on the conduct of the disciplinary and appellate authority, because the disciplinary and appellate authority have criticized the presenting officer, saying that the presenting officer had not come prepared and that there were no screenshots, no evidence. So my lord has asked this question, that if they have not come prepared, there was no screenshot of evidence and so on, then how can you rely on them and you pass your orders? On that ground alone, you had quash charge number 4. So the behavior of the, and that apart, lordship, when the, may I just show this Justice Sen's observations? That is part of the judgment. Judgment Akul. Justice Sen's observation is part of the judgment. This is page 549. 549. Para 21. Page 549, para 21.
Yes.
In considered view of this court, if the appellate authority himself is of the view that in the inquiry proceedings, the presenting officer of the respondent bank did not come prepared to present the case of the management in a proper manner and had failed to adduce documents in the inquiry proceedings to substantiate charges. Then on what basis he took a contrary view to the findings of the inquiry officer, especially when no materials have been placed before this court, that either before the disciplinary or before the appellate authority fresh evidence was taken, either oral or documentary. And the decisions of the disciplinary and the appellate authority are the outcome of such fresh evidence. In view of the discussion made herein above, this court has got no hesitation to hold that the findings of the appellate authority suffer from patent error, which is apparent on the face of the record, and thus the findings of the disciplinary authority and the appellate authority with regard to charge number 4 are hereby quashed and set aside. Now, Lordship, in even otherwise, what happened in this case was that the disciplinary authority had asked the petitioner, after the inquiry report was submitted, the disciplinary authority asked the petitioner for his comments. So the petitioner gave his comments, which are all here on record. Subsequently, the disciplinary authority, without holding any fresh inquiry or without giving any opportunity of hearing, stated that he agreed to certain.
We don't think you please explain our query first. Our query is charge 1 is misappropriation. Maybe inquiring authority has held in your favor that there is no misappropriation. DA and AA has affirmed the finding that charge 1 is true.
Then I have to place the evidence.
No, we will not allow you that because you have not challenged the charge. Your appeal before us is not challenging the charge. You are accepting the punishment.
No,
After acceptance of the punishment, the outcome of which had been that your prayer has been, you have termination set aside and you have been reinstated. Now, if you go on and say that, no, now I have got the punishment, this punishment cannot be appertinent to a charge of misappropriation. This is impossible. That argument itself you could have advanced had you challenged this order.
But can I escape with this punishment
Mr.
in case of
Chakraborty,
misappropriation? This is not a no, Lordship. My Lordship,
have you accepted or not?
I have accepted
Then you have
a minor
accepted.
penalty.
No, that this slipshod manner won't happen. Then you ought to have challenged the judgment. That why did you, when misappropriation is not proved, why did you impose even the minor punishment? Your argument is the minor punishment cannot be appertinent to a charge of misappropriation. So that expunge that remark that misappropriation has to be expunged. Sorry, we cannot do that because you have not challenged the charge.
But at the same time, okay, Lordship, if I agree, even assuming that you, okay, this is correct. This is the correct.
Where do we find that you have not challenged the judgment?
No, but may I say this?
Finding হচ্ছে his honesty and integrity is questionable. এটা যদি চ্যালেঞ্জ না করে এটাকে হাত দেবো কোন থেকে? ও তো জাজমেন্টে চ্যালেঞ্জ করেননি। Only expansion of the remarks in the charge. You should have been silent that I am challenging part of the order. Finished. And you could have filed an application for appropriate order in the appeal. We could have taken it up your arguments. You yourself started your submission saying I am accepting the punishment, but not the charge. How that is possible?
Because my only submission was that that charge is not commensurate with the punishment. That was my only charge. Because I was terminated from service.
Then we increase the punishment. If you say that the punishment is not commensurate with the charge, then we will say.
Lordship, why I was thrown out for 10 years.
Observation.
My lord, my case is on some other footing. Even if I admit the contents of my landed friend, then also perhaps I am protected. The reason being, my lord, we are the bank, and my lord, in all banking, my lord, transaction, the integrity and honesty is of paramount consideration. The facts are admitted, my lord. Only the thing is this: my learned senior friend was trying to agitate that the alleged misappropriation of fund was not the actually misappropriation of fund, but rather an technical violation. So, my lord, the banking business itself, my lord, is based upon technicalities. The money comes, money goes. And in between, my lord, the procedure is to be followed. And what are the procedures is to be followed, my lord? You have to check, verify whether the, my lord, the document checks are, my lord, properly signed or not, whether those are presented by the actual account holder or not.
Mr. Bormon, you also know that there has been no misappropriation.
My lord,
Because
I will agitate that.
You will agitate. I am asking, I am speaking with the officer of my court.
My lord, my lord, my lord. My lord, but
As a client's advocate, you will say many things, but we are just sharing with you that Mr. Bormon, you also very well know that it is not strictly misappropriation. There was a technical fault but a problem has been created by him because the learned judge has said categorically that his integrity is doubted.
my lord,
This will, in fact, if the
my lord,
bank.
may I submit whether it is only on this issue, misappropriation of fund? I can understand what has fallen for your lordship. I am conscious of this, my lord, that this kind of question is likely to be befallen upon us, my lord. Whether it is a misappropriation of fund or not, let us see, my lord, the charge. What is the charge?
Okay.
Charge is this, what is the charge, my lord? The charge is this, my lord, the particular sum of money, that is 25,000, was supposed to be sent to Mr. A. That is the, my lord, the borrower. A is the borrower. I am the bench manager or the, my lord, the appellant here. So that particular 25,000 sum of money was supposed to go to Mr. A, who is a borrower. Instead of that, that money has gone to my wife. That is B. That is admitted fact. Now, what is the defense of my learned senior friend is this? Why I have sent the money to my wife? Because my wife has lent that money to the borrower. Because he was in hurry of taking money. That is his defense. Whether that defense would be tenable or not, my lord, that I will try to, my lord, demonstrate. The defense is this.
He explained saying that the money.
My lord, money admittedly is supposed to go to borrower.
Yes.
But in this case, the money has gone to his wife. What the explanation the branch manager is given, that why I have sent the money to my wife, because that person borrower was in hurry. That is his defense. Was in hurry to get that money. The bank has certain technicalities to follow to disburse the money. So that is why he requested my wife to give the money. So my wife has given on lent that money, and since my wife has already given that money, so accordingly I have given that money to my wife. Is this permissible, my lord? That is my humble question to myself.
Not permissible.
Yeah, that is the question. If that is so, my lord, then how this misappropriation of fund will not happen? Because we do not know.
Intent.
Yes.
What is his
My lord,
intent?
in banking transaction, my lord, that cannot be
His,
proved,
his
my lord.
action, you have rightly pointed out, he could not have credited this amount to the wife's account.
Wife's account. And once that is done, my lord,
Once that is done, it will tantamount to misappropriation.
Misuse of fund.
Ultimately, if that amount goes away from your
Now
account,
the intent, my lord, means is that would have been a very
Ah.
material consideration for criminal prosecution. My lord knows it is
have
a
you lodged any complaint?
yes, my lord, FIR is there, we have taken it, admitted fact. FIR has been lodged. Immediately FIR has been lodged and FIR has been registered as well. The intent perhaps in criminal prosecution is my lord, paramount consideration or important. In this case, my lord, preponderance of probability, no proof beyond reasonable doubt. So with being the banking, my lord, organization, we have supposed to repose faith upon our customers, my lord. A single, my lord, dereliction of duty should be treated. And if, my lord, I takes your lordship to the various regulations of the bank that has been, my lord, referred to by, in the order judgment impugned, if my lord kindly takes up that regulation that is reflecting in, my lord, internal page number 18 of the judgment impugned, my lord. Kindly sees once the regulation.
Now,
A
Mr.
single-
Bonon, what about the second charge and third
Mala
charge?
second charge, Mala second and third admitted case we did not praise because it
And-
actually did not praise Malad in Malad before the disciplinary authority. It was held to be not proved. So that is why Malad appellate authority did not consider those charges.
Also, disciplinary DA did not find charges
Yes, proved to be
clear.
proved.
Charges 2 and 3 proved.
That is why Malad the appellate authority did not deal with it.
Very good. And what
As so
about
far the charges 4 is concerned, my lord, far as my learned senior friend has forgotten, there were total 17 sub-charges. It's not that one charge 4. Under charge 4, my lord, there are total 17 sub-charges. And out of that, my lord, 3 charges has been proved both by the discipline authority as well as by the appellate authority. Total, my lord, 18 charges were there. Charge number 1 and 17 charges under charge number 4, or rather 17 sub charges under charge number 4, my lord. So out of 18, my lord, what I can find from the my lord, the findings or orders of
4
the
was proved?
my lord, total, my lord, yes, 4 was proved. Few of the sub charges 4 was proved, my lord. May I, my lord? My lord, total 3 charges were proved by both discipline authority as well as appellate authority out of 18. And another 3 charges were proved only by the appellate authority. So total 6 charges were held to be proved. And in
No, just go slow.
yes,
3 were proved by both DA and A.
3 charges. That is charge number 1, charge number 4.4, and charge number 4.8.
4.3 and
4.8. Those are, my lord, fully
Just-
proved, I should say. Fully proved by both discipline authority as well as appellate authority.
Yes.
And charge number 4.2, 4.6, and 4.10. Those are held to be proved by disciplinary authority. And these 3 charges, those have been fully proved by the disciplinary my lord, appellate authority. Those were, my lord, were held to be partially proved by disciplinary authority. This, my lord, the second 3 charges that I have just, my lord, quoted, 4.2, 4.6, and 4.10. These 3 charges were held to be partially proved by discipline authority, which their appellate authority held to be fully proved. So out of 6, my lord, out of 18, my lord, 6 charges were fully proved. And thereafter, my lord, 9 remaining charges were to be partially proved out of 18. Now, my lord, while quashing, my lord, the charge number 4, if I, my lord, the text of the
Just
judgment impugned,
charge sheet 526. Charge sheet is which page? Charge sheet 176, na?
my lord, charges has been repeated in the findings of disciplinary as well as appellate authority. If I am allowed to present that
176.
Yes, place. What do you want to place?
Yes, my lord. If my lord kindly comes to the judgment and order impugned,
Hmm.
paragraph number 24, regarding misappropriation only, my lord. What are the regulations? What were our regulations so far this misconduct could have been established, my lord? Paragraph number 24 of the judgment impugned, my lord, the learned single judge has reproduced the regulation, my lord.
Hmm.
The first, there are total, my lord, 4 regulations. I will rely upon 1 and 4, my lord. Every officer employee shall maintain good conduct and discipline and show courtesy and attention to all the person in all transaction and negotiation. That is, my lord, the regulation number 1. And if my lord turns to the next page, regulation number 4. Every officer employee shall take all possible steps to ensure the integrity and devotion to duty of all persons for the time being under his control and authority. Thereafter, my regulation 24. A breach of any of the provisions of this regulation shall be deemed to constitute misconduct punishable under the Central Bank Officers Employees Regulation 1976. Thereafter, penalties, my lord, major penalties. First is,
This
my lord,
regulation-
minor penalty, thereafter major penalties. My lord, we imposed, my lord, the punishment on under major penalties, my lord. That is termination without any option for re-employment. Dismissal from service without any option for re-employment. Now the question is, my lord, as per the finding of single judge is concerned, my lord, the findings has been established. The misappropriation of fund, my learned single judge has held, and the charges has to be proved. That is also there, my lord, reflection. So if that is so,
What is the finding as regards charge 4?
charge 4, my lord,
Yes.
without dealing with each and every allegations, my lord, the court has simply said it has quashed reasonably, my lord, probably on the ground that there is one, my lord, the findings of the appellate authority while making the concluding remark after dealing with all the charges, my lord, the appellate authority. In the concluding remark, there was certain observation by the appellate authority that the presenting officer, while dealing with the case, did not come with proper, my lord, instruction or preparation. I'm sorry. Preparation. So on that ground, the appellate authority made certain casting remark against the presenting officer. So taking the cue from that observation,
Each paragraph.
my lord. I am.
Hmm.
Charge 4 quashed. Paragraph number 22, my lord, the charge 4 has been quashed. Paragraph number 22.
And where is the appellate authority order?
Yes, my lord, I am placing. May I just read the paragraph 22? If before that, my lord, if my lord comes to paragraph number 20. The discipline authority, however, did not fully agree with the finding of inquiring authority. I found that in most of the cases, the loan was transferred to borrowers' saving accounts instead of direct payment to the supplier. In some cases, borrower were allowed to divert fund. In the finding, appellate authority, however, held thus. I failed to understand the point in conducting post-sanction inspection within truth. That is, my lord, technicality. On the next page, my lord. I also find from the above that the presenting officer has not come prepared in the inquiry to present bank's case in a proper manner. He has failed to adduce documents in the inquiry based on which the charge sheet was framed, like the screenshot of relevant accounts where the transaction details could clearly be perceived. So that is one of the, my lord, fleeting remark that was made by the appellate authority. Thereafter, my lord, the learned single judge's, my lord, finding. In considered view of this court, if the appellate authority himself is of the view that in the inquiry proceeding, the presenting officer of the respondent bank did not come prepared to present the case of the management in a proper manner and had failed to adduce documents in inquiry proceeding to substantiate charges, then what basis he took a contrary view to the findings of inquiry officer, especially when no materials has been placed before this court that
So
either.
What was the contrary view of the inquiry?
Yes, my lord, my lord, I'll take your lordship to the appellate authority finding, because that is, my lord, my the fulcrum of my submission. That would be, my lord, because there's a very detailed, my lord, finding, a detailed order, and each and every evidence has been reflected by the order of the appellate authority. By the order of the appellate authority, my lord, each and every charge has been analyzed in a quite detailed manner, most detailed manner, I should say. Thereafter, my lord, paragraph number 22. In view of the discussion made herein above, this court has got no hesitation to hold that the findings of the appellate authority suffers from patent error which is apparent on the face of the record, and thus the findings of the discipline authority and the appellate authority with regard to charge number 4 are hereby quashed and set aside. In block, my lord, all the charges were set aside. That is my lord first my lord limb of my submission. Secondly, my lord, if my lord comes regarding charge number 4, my lord, if my lord comes to initial paragraph, the learned single judge has also reproduced few of the sub charges of charge number 4. If my lord comes to paragraph number, because my lord, the learned single judge, while dealing with charge number 4, did not deal with the 17 sub charges. If my lord kindly comes to paragraph number 16 of the judgment impugned.
Yes.
Paragraph number 16 is internal page number 8 at the bottom. 1, 2, 3, 4, 5, 6, 7. Only 7 mala sub charges the learned single judge referred to, which is not the fact mala. Admitted fact mala 17 sub charges. So in that case, the remaining sub charges were not considered by the learned single judge at all. Even if I consider this part of the learned single judge is right while quashing the charge number 4, because the learned single judge was considered only the 7 sub charges of charges number 4, whereas there were total 17 sub charges. Now, my lord, if I take your lordship,
But that merges with the observation made in paragraph 21. After so much of labor, paragraph 2, appellate authority was sent to the docks. So what remains? Quoting the observation of the appellate authority.
yes, my lord,
So if the
may I?
very order becomes discrepant,
No, my lord, that is not. I'll show, my lord. That is not. Only for because of that observation, my lord, the appellate authorities perhaps finding cannot be vitiated with. I will place, my lord, the appellate authority order. It's a very elaborate order, my lord. The appellate authority order starts at, in my lord paper book. I will rely upon my
428.
paper book, my lord.
428, appellate authority.
এই যে part 2 যে observation টা করলো,
349 of my paper book, my lord. Volume number 2. Because I have made certain notings in my paper book, my lord.
page 4.
349 of volume 2 of my
No, no,
paper book.
we will go by this paper.
Yes, okay, very well, my lord. Very
You place it from your
well. Yeah,
paper.
very well, my lord.
This is 428, na? তুমি বললে?
420.
Please open the 428. Yes, yes, my lord. I'll keep that, my lord, volume also with me. 428. Volume 3. But volume 3 is not volume 3 থেকে দেওয়া যাবে?
Yes, 428.
Yes, my lord. If my lord comes to internal page number 3 for the charge number 1, because that charge has been proved by all the authorities. Inquiry authority has held partially proved. So proof is there. Now the question is, one point my learned senior friend has agitated. They think there is a, my lord, the findings of the inquiry authority that it is not totally proved. So they will perhaps will try to take advantage. But it is established, my lord, settled law that the disciplinary authority and both the appellate authority can disagree with the findings of inquiry authority. Inquiry authority job, primary job of the inquiry authority is only to produce the document. So far the formation of, my lord, the opinion or finding is concerned, that is the disciplinary authority and the, my lord, appellate authority. And that apart, my lord, our service regulation also permits us to disagree with the findings of appellate inquiry authority. So far the disagreement of findings of inquiry authority is concerned, my lord, we are perhaps protected. Now, if my lord comes to the charge number 1,
কার্তিক কোথায়? কার্তিক কোথায়? কার্তিক কোথায়? নেই। বেরোয় গেছে। ঠিক। যে এই
the charge state that the appellate
just one more. এই লোক
Internal page number 3, my appellate authority's order. The charge number, my lord has got it. Charge number 1. So instead of repeating, my lord, the first my lord, charge number 1 has been, my lord, reproduced. Thereafter, presenting officer's brief has been, my lord, dealt with. My lord, kindly comes the later part. Defense argument has been dealt with. Then inquiry authorities findings has been dealt with. Thereafter, on the next page, my lord, the disciplinary authorities, my lord, findings has been dealt with. Thereafter, my lord,
So charge 1 is proved, no problem for that.
no, why I'm taking with the in all detail, because the learned single judge has taken, my lord, the point that the appellate authority has made an observation that the presenting officer did not prepare himself properly at the time of inquiry. So what I'm trying
Maybe
to
at the last
demonstrate,
portion. That may
that is
be.
the last concluding part.
Uh.
So what I'm trying to demonstrate is, my lord, this order is very detailed. Each and every aspect of each of the party's case has been properly dealt with, and thereafter finding has been given. If my lord kindly comes to the finding of charge number 1 once.
আরে
Page
গোড়ায়
5.
কেটে দিয়ে আর আগায় জল দিয়ে কি হবে? আলটিমেটলি সবকিছু বলে টলে বলেছে দিস ইজ দি ইনফরমেশন। তাহলে গোড়ায় কেটে দিয়ে উপরে জল দিচ্ছে।
No, my lord, perhaps it is not done. Perhaps it is not done, my lord. It is not done in this way, my lord.
Lordship, since I,
Mr. Chakraborty, we will come back to you. Let him finish.
And that I will come to that point, my lord. The law is quite settled, my lord. The power of
Charge
appellate
1, we are not hearing him because charge 1, it has been proved.
proved, my lord. So far,
And a remark has been made that there is lack of integrity, etc., which he wants expunction.
yes, but
So now come to the satisfy us as regards the other parts of the what
Very
is the wrong
wrong of, my lord,
of the single judge in throwing away your order.
because, my lord, the charge number 4 has not been dealt with only because of that observation. That is why I was demonstrating the appellate authority's order.
Your
Because
contention is the court did not go into the detailed reasoning given by the appellate authority
yes, my lord,
in
whether
respect of each and every charge on the banking on a particular observation made at the fag end of
yeah,
the
yeah, absolutely right, my
Yeah,
lord.
understood.
That is the point, my lord.
Hmm.
Because, my lord, the power of the writ court in 226 in
We
service jurisprudence.
appreciate evidence.
Yes,
of-
the appreciation of evidence only based on no evidence. Even, my lord, sufficiency of evidence is of no consideration. Even if I, for argument's sake, I assume that there is some evidence, then also it is enough for me to impose the punishment. It is nobody's case, my lord, there is no evidence. If that remark is there, my lord, that perhaps that is a case of lack of evidence, insufficiency of evidence. That is also not enough for the purpose of intervention of writ court, my lord, in service jurisprudence for imposition of punishment. It is an administrative order. Only the process is to be looked into, not the ultimate decision, my lord.
Hmm.
If my lord, I take your lordship to the fag end of this observation, where he has made. Before that, there are a lot of discussions were there. Not that that is the only discussion the appellate authority has made. If my lord kindly comes to the
Internal page,
last but the one page, my lord.
internal page 17.
Internal page 17 is the last page, 16, my lord. If my lord, the previous page.
Last
I-
page is 17.
17, the previous page, my lord. Therefore,
Yes, where you are.
start. I therefore agree with the findings of DA. From the above, it comes to the fore that there has been gross and grave lapses on the part of the appellant. More, when he was aware that going for part disbursement in loan cases were advisable as stipulated by the bank. I failed to understand the point in conducting post-sanction inspection within 2 or 3 days of disbursement of entire bank loan in one shot, and that too directly to the borrower in case of mini rice mill, chira mills, husking mills, dairy farm project, and certifying in the inspection report that funds has been utilized in business as per the project submitted. I also find from the above that the presenting officer has not come prepared in inquiry to present the bank's case in a proper manner. He has failed to adduce document in the inquiry based on which charge sheet was framed like the screenshot of relevant account. That is one of the aspect charge sheet of rather screenshot of account was one of the many aspects, my lord. In one particular case, my lord, for the sake of argument, if I admit that is one aspect, my lord, the presenting officer may have faltered, but there are other aspects of evidence as well. We must not forget that the objective of disciplinary action against a member or staff is to perform the employee, or in case of serious misconduct removes him or her because of misconduct in the discharge of official duties, is to be viewed as an unlawful behavior of the officer in relation to his or his duties, which is willful and in character, performed in transgression of established and definite rule of action or code of conduct. The purpose of disciplinary action is also to deter other employees from similar conduct and to maintain the purity and efficiency of the organization. Then the last page, my lord. In respect of the subject appeal, I have found that the action on the part of the appellant in dealing with the loan account as mentioned in the entire charge sheet have all along remained wayward, malafide, knowingly that he has flouted the lending norms and restored to the practice of misappropriation in crediting the savings bank account of his wife with funds that was to be remitted to the supplier of farm equipment, harping on the plea that the money did not belong to the bank. It is therefore observed from the totality of the case that the submission made through the appeal have not been able to demolish the structure and spirit of the subject charges, which have been found proved by the discipline authority with particular reference to charge number 1. The appellant is found trammeling to interpret the charge number 1 only and that too in a different way. In fact, nature of evidence lead in charge number 1 is direct, explanatory. The record of the case substantiate the charge appearing against the appellant. As for the various segments of charge number 4, I found that the appellant to be evasive in his submission in the appeal. The appellant only attempted to contradict the findings of DA, which I found were based on exhibits and evidences produced in the inquiry. So there were evidences. Only one case, my lord, the appellate authority pointed out the screenshot. Perhaps that is not there. That is one of the many evidences, my lord, that was produced before the inquiry. No new evidence material has been adduced by him or has been put forth any such argument which would have support his claim. I therefore confirm the consolidated punishment imposed by the disciplinary authority, which is as under dismissal from service in terms of regulation 4J of Central Bank of India officer employee regulation as amended up to the appellant is the
So has there been any misappropriation of fund in respect of charge?
My lord, the other charges, may I just summarize, what are the other charges? In all the charges, my lord, these were very, my lord, I should say, like MSME sector, small borrower. They either run a chira mill or husk mill or, my lord, gotari. So they take small amount of loan, like 25,000, 30,000. And while the loan is, my lord knows that once the loan, for example, I am buying a, my lord, flat. So what will happen? I will apply to the bank. The bank will disburse the money to whom? Not to me, but to the developer. Because that is the actual place where the money should go. Otherwise, if the bank gives the money to me, then I may misappropriate for other purpose.
Please come to charge number 4. Let us see the
My
charge.
lord, absolutely, my lord. If my lord, I come to, for example, phone number 4, my lord. For example, phone number 4. That because that was proved by both the discipline authority as well as appellate authority. Phone number 4.
Point number?
4.4, my lord. That is pen number.
No, let us see.
Here, my lord.
What is
Here, my lord, phone number 4. 4.4, I am sorry, my lord. 4.4 is internal page number 6.
how you are? No, please come to the charge sheet now.
Oh, I am sorry, my lord.
Term loan
Charge sheet.
charge number.
Why, my lord, I came to this because the same charges has been reflected, my lord, reproduced. The charges has been
That is
reproduced.
the internal page.
My lord, 6. That is why, my lord, I am here. The whole charge has been reproduced. Internal page number 6, my lord.
Of the judgment.
Of the, my lord, appellate authority's order. Because first he has reproduced the charge, thereafter he has came to his own findings.
Yes.
For example, phone number 4.4. Term loan such and such, Mr. Devolina Nath Roy, project cost 5 lakhs for husking mill, 25,000 government subsidy, 1,50,000. I'm sorry, margin money 25,000 because 25,000 is to be given by the borrower. 1.5 lakhs is the subsidy to be given by the government, and bank loan is 3.25 lakhs. Almost entire bank loan and subsidy was allowed to be withdrawn from savings account within 7 days. Balance savings account as on such and such is rupees 12,000 and odd. No new assets were created out of the bank loan and end use of the loan is not ensured. What is supposed to be done, my lord, once the bank loan is to be disbursed, that should go to the supplier, not to the borrower. This is the, my lord, banking now. But in this case, again, my lord, the money went to the borrower himself. And there is no, my lord, finding.
Where do you find that? Term loan of account of Devendra Nath Rai. Term loan was taken by Devendra.
Yes.
Project cost was 5 lakh
5
for
lakhs.
husking mill.
Yes.
Margin was 2,500. Government subsidy 1 lakh 50. Bank loan is 3 lakh
0.25. Yes.
Now,
the borrower has an existing husking mill. Disbursement made on through savings account. Saving accounts means the savings account of the borrower. Almost entire bank loan.
And subsidy was allowed to be
withdrawn from savings account. What happens, my lord? The loan account is to be.
Let us see. Loan
account is different. Kindly see at the very beginning, the term loan account is mentioned. Yes, so the money should have been gone there because that is the loan account. The money should come here and thereafter whatever is to be done. In this case, the money came to the savings bank account of the borrower.
We are wanting to know from you where it has been said that the bank money was misappropriated.
Well, this is misappropriation. So far, misappropriation is
was
concerned, that is
charged
one. And so
Under
far,
charge
these are,
code,
yes,
there
under
may be
charge code,
irregularity.
yes, various irregularity.
The bank did not lose any money.
My lord, maybe because the bank money.
No, you
Why
say
I'm
why maybe?
yes,
You
see,
show
very
us
well. Yes,
that
yes.
there was
I
any
rephrase
loss
myself.
of.
I rephrase myself. Why? Because may I just give a very small example? Why the money always goes to the actual place where the money is meant to be? For example, I am trying to buy a property. Then, my lord, the property is to be secured.
We understand your logic.
That
So
here also,
if I take a car loan today, bank will not be giving the
Yes.
money to me.
but to the my lord, the showroom or the my lord, car
Yes,
manufacturer.
Yes.
So here also the money should go to the my lord, for the purpose the loan is
So
to be
it has
taken.
not gone. That
It,
is the
it has
wrong-
not gone, but gone to the borrower. Now,
That is a wrong procedure.
the wrong procedure.
By virtue of that, did you suffer any loss? We want to see that.
If we cannot recover this money, what will happen? For example, because once we give the money, security is to be
Show
created.
us, show us that is the charge against him.
Well, charge is on the very beginning, the
Charge is
4.4.
irregular disbursement of loan. Charge is not that you have misappropriated the money.
No, my
These are
lord.
all
So
village
far the
loans.
sub charges 4 is concerned, my lord, that is not a case of misappropriation. I must admit.
Charge for
So far the
charge any one of them was misappropriation.
one is misappropriation.
That is charge one.
Charge one, yes. Yes,
That
sub charges
we
are not, yes, yes. If I say so, 70 sub charges were not for misappropriation of, my lord.
Not for misappropriation.
No, not for
That was
misappropriation.
an irregularity.
Irregularity.
Now the trial judge said that it was an irregularity. But after discussing so many things, the appellate authority says that the presenting officer did not properly place his case. That observation cuts both ways. If the presenting officer does not place the proper case properly, prosecution will not be able to prove.
But that is, yeah, that is why, my lord, I was, my lord, the showcasing whether that is so or not, because there are lot of evidences, because it is admitted case, my lord, the lot of my lord evidences were exchanged. My lord, exhibits were numerous. My lord, what the appellate authority has held, that in one case, my lord, the screenshot of the account was not produced. Well, there are numerous evidences, not that only on the basis of one, my lord, evidence the charges were proved.
We understood.
List of documents were there, my lord. It is there, my lord, on record. List of documents were exhibited by both the parties. Evidences were, my lord, weighed upon by both the disciplinary authority and appellate authority, and accordingly the findings were given. But appellate authority indeed made a finding the presenting officer did not prepare to the expectation, perhaps.
Mr. Borman, where do we find that chart? that some charges were partly proved by the.
Yes, my lord.
Do you have any annex?
Yes, I have a noting, my lord. Right now I can. For example, charge number 4.1 has been partly proved. That is at page number, internal page number. May I show it? Internal page number 8, my lord. For example, charge number 4.1. That is partly proved.
ঠিক আছে।
Because last line is I therefore agree with the observation of DA. So DA held that the charge was partly proved.
Page number 8, where do we find partly proved?
Madam, it is not there. It is I therefore agree with the observation of DA. So if I take your lordship to the observation of DA, then it can be found, my lord, the charges was partly proved. May I take
No,
this, my
next line it is given segment of charge 4 found partly proved. That is 4.1.
Yeah, DA's finding.
Segment.
Found partly.
Then 4.2 so is already proved, my lord.
এখানে আমি দেখেছি ওই ভার্স।
And in any case, my lord, so far that observation is concerned, that would perhaps go to the sufficiency of the evidence, not the lack of evidence, my lord. It is a case of the appellant perhaps can survive if there is no evidence, case of no evidence. If there is a sufficiency or insufficient evidence, that is not the subject matter of the read court to intervene, my lord. And so far the amount is concerned, my lord, 25,000 is admitted, my lord. So I will, my lord, cite few decisions to show that the amount is of little consideration. Any negligible amount can be held to be a gross misconduct, and that may lead to, my lord, termination from service.
হুম। Yes.
So, my lord, so far the judgment of the learned single judge is concerned, my lord. So once the finding is there that the misappropriation has been proved, it is there, my lord, which my learned senior friend is seeking to expunge, my lord. First argument is this, my lord, the expunging of findings cannot be exchanged. Findings can be either remain or set aside.
Yes.
It cannot be expunged. It is a finding, not a fleeting remark or, my lord, the observation or any casting remark has been given. That would have been the difference. It is a finding that a misappropriation has been done. So once that is done, my lord, now the question is whether the major penalty can be converted into minor penalty. That is the, my lord, subject matter of my submission. So, my lord, in that case, my lord, I'll try to, my lord, demonstrate that the law is this, my lord, the misappropriation property is there, my lord, the amount of money is of little consideration. That I'll cite few decisions, my lord. May I, my lord? My lord, so far,
Yes.
Supreme Court decision, my lord. If my lord kindly comes to paragraph number, only the relevant paragraph I will, my lord. The first is paragraph number 3, my lord. It's a
Yeah,
very
yeah,
small judgment, my lord.
Right.
हाँ, দিয়ে দিচ্ছি, একটু বলে না, আমার কাছে copy আছে। if my lord kindly see the paragraph number 3, the question involved in this appeal is whether High Court,
Just a moment.
I'm sorry,
Year 2006 Supreme Court 3129. Para?
para 3, my lord. First para 3, thereafter another paragraph.
Yes.
Para 3 says, my lord, the question involved in this appeal is whether High Court was justified in confirming the order passed by the Labour Court, reinstating the respondent workmen with 25% of the back wages in spite of specific finding of the fact that the charges of breach of trust and misappropriation of good for the value given in the said charges had been clearly established. Apparently, it would be an unjustified direction to reinstate an employee against whom charge of misappropriation is established. A proved act of misappropriation cannot be taken lightly, even though the number of such misappropriation cases remain undisclosed and such employees of others amass wealth by such means. In any case, misappropriation cannot be rewarded or legalized by reinstatement in service with full part or back wages. Thereafter, if my lord kindly comes to paragraph number 6. Next page, my lord. As stated above, the learned single judge and the division bench in writ appeals confirm the findings given by the Labour Court that the charges against the workmen for breach of trust and misappropriation of funds entrusted to them for value mentioned in the charge sheet has been established. After giving the said findings, in our view, the Labour Court materially erred in setting aside the order passed by the management, removing the workmen from service and reinstating them with 25% of back wages. Once act of misappropriation is proved, maybe for a small or large amount. Maybe for a small or large amount, there is no question of showing uncalled for sympathy and reinstating the employee in service, my lord. Thereafter, my lord, the other part has been discussed. It is a similar case.
Did he have any antecedent?
No. My lord, I will show, my lord, that is also cannot be considered, my lord. Past good work cannot be considered, my lord. Once, my lord, is there misconduct is misconduct. It is there, my lord. It is held by the Supreme Court, my lord. The past good conduct should not be swayed upon the court, my lord, to reverse the finding of misconduct. That decision I have not prepared today, but it is there, my lord. If my lord allow, then I can cite that decision. Thereafter, the next decision, my lord.
So when there has been no loss to the bank, a person will be dismissed.
Refund this section, my lord, this, for example, before I cite
You
this,
can proceed on the basis of the fact that his character must be impeccable.
impeccable.
He is there are 4 judgments to that. Bank service is not to be taken lightly, so it should be impeccable, like in discipline forces. But the thing is, disappropriation, the disproportionateness also comes into the picture.
Disproportionate case is something, yes, something else. My lord, suppose the money has been.
No, they are also disproportionate. There are a plethora of judgments wherein the finding of unauthorized absence or say insubordination of the superior authority.
Yes, my lord.
Dismissed.
Dismissed.
Serious punishment. There are innumerable instances where court said that is creating civil consequences. His family will be destroyed. You don't throw him out of the job. As such, I am imposing a further punishment. Maybe that punishment is not sufficient according to the bank. It is a substantial lowering the time scale of pay means he goes to the lower rungs of the pay scale, though being a manager.
My lord, the case is this, once a misappropriation
No, we
there,
appreciate
the
your
banking
argument.
organization, we cannot remain, he cannot act in a, my lord, we cannot, if I say so, we cannot trust that person anymore. If there is a misappropriation of this thing, he has, because we do not know, the evidence is there that that person has again come back and said,
What is misappropriation?
Misappropriation, the money has gone.
Somebody else's money, I am taking it for utilizing my purposes.
That is their case, my, there is no proof, my lord. That man has come. Initially, I was trying to submit, my lord.
No, you admit that bank has not lost any money. There had been a technical fault.
My lord, the money has gone to his wife, my lord. The money has gone to the wife.
That is a technical wrong. Because for that you have not been prejudiced in any manner. It was an error on the part of the person. We could have understood that he has sent that money to the bank, to the wife, and it has never been credited to the scheme.
That was intentional act, my lord, a deliberate act.
But the end product is the bank has not suffered any loss, neither in charge 1, neither in charge 4. In the said backdrop,
that is certainly, that is one aspect, my lord. That certainly, my lord, I must admit, that is one aspect. Another aspect is this, my lord, we do not know, that why I'm trying to submit. We do not know what actually happened.
He has
Because-
already been stigmatized.
Because the borrower,
Never get promotion.
my,
Nothing. Bank
just a second. The
will rot him in his place.
may I? The borrower, later on, the borrower has given a letter to the bank because of this, my lord, the money has been given. So we do not know, my lord, what actually transpired between the two. It may have been defalcation of money had it been not, my lord, disclosed in
Maybe
appropriate
some
time.
other big purpose.
Yes,
also.
yes, other thing may be different. We do not know, my lord. Only because borrower has
Yes,
given a
sure.
letter that I have got the money, that is why given. So cannot trust. That is no value of the document, because with the next, sir, how a borrower can know branch manager wife, my lord, that he will go and beg the money from his wife, my lord. These things are of consideration, my lord.
Any other judgment?
Judgments
Mr.
are there. Few.
Yes.
Only 2 or 3 lines I will, my lord, highlight.
No, no, you all right.
Well, my lord knows, my lord, the settled position only for my
No,
satisfaction.
no,
my
right. We are not.
For example, in this particular case, my lord, the misappropriation was there, but the money was later refunded. So that refund, that is why I was trying to submit, my lord. Even the refund is not enough. Even the refund would not, my lord, purge his, my lord, the act of misconduct. That is, my lord, paragraph, my lord, 1 and 6, my lord. The learned counsel for the appellant also submitted that the appellant has already paid back the money which was held proved against him that he has misappropriated. Mere repayment of money does not absolve him of serious charges of misappropriation. Perhaps, my lord, this
Paragraph?
decision may, my lord, give some kind of reply to what has happened.
Paragraph?
Paragraph 6, my lord, the last paragraph. Paragraph 6. Then, my lord, amount of money. The Supreme Court has held, my lord, the amount, even if it is
Immaterial.
yes, immaterial, my lord. Negligible or, my lord,
5 rupees or 10 rupees?
yes, my lord. That, my lord, the famous conductor case, my lord. One rupee and some paisa was held to be, my lord. My lord is aware of paragraph. Now, then I'm not repeating. I'm not.
There is a counter argument to that. That is, yes, if you got the theft of 2 rupees, if you send the person, terminate him, you are sending him to gallows.
Gallows,
He
yes,
will
yes.
become.
From
he
my
will
lord,
become a
humanitarian
dacoit.
view. From humanitarian view, certainly. But in that case, my lord is aware of the recent judgment of the Supreme Court, my lord. My lord judgment, perhaps, that the panel, cancellation of panel. There are several, my lord, good candidates were there, but nevertheless, they are suffering. So for making one good, my lord, some loss is to be given, my lord. So we are a banking organization, my lord. We have to think of lakhs and crores of, my lord, customer than one branch manager, my lord. Maybe his one family may be jeopardized, but we have to think of, my lord, the other family members of lakhs of our customers, my lord. If their money is, my lord, stolen, they will be in trouble.
Yes.
Well, it is, my lord, the paragraph number 5 and 6. I am not repeating, my lord. Paragraph number 5 and 6, my lord, dealt with
This is
the negligible, but the amount is, my lord.
this is Andhra Pradesh High Court.
Well, yes, my lord, but the summary of the Supreme Court decision has been given. That is why instead of producing 2 decisions, my lord, I am giving the division. My lord, paragraph number 5 and 6.
Achha.
Supreme Court decision has been summarized and that finding has
That
been
has
given.
been
Yes, my lord. And my lord is aware of that.
No, we are not aware of anything. You make us aware.
My lord, that Gunosekaran decision, my lord, the points of, my lord, has been given. Only one paragraph I will, my lord, cite, where, my lord, the paragraph 12 and 13. এটা দিয়ে আমি বলছি। If, my lord, just have a glance of that particular paragraph, where the writ court can intervene. Page number 5.
Have you gone through our recent judgment? Please go through it.
My lord, certainly, my lord.
One that is 2025, Volume 1, Supreme maybe.
My lord,
Court went to the angle. Court winner. That is a judgment of Justice Dotto was delivered.
I see.
So we found it. Article
contract Pioneer Builders case, my lord. The buyers have to only sign the dotted lines.
Law is evolving.
Evolving,
Law
certainly,
is
my lord.
evolving every day. So you
On the
are
other
right.
day, my lord, I have seen a 2 judges division bench of Supreme Court has distinguished the full bench decision of Supreme Court. I do not know, but
So that dispute was from Tufan Singh. When under NDPS Act 161 statement cannot be on the band, on the basis of that statement, you cannot
cannot.
co-accuse
conflict.
statement.
A2, my lord, the grounds of, my lord, the intervention of writ court is given. For example, the inquiry is held by competent authority.
Paragraph.
Paragraph number 13, my lord. In this connection, may I just submit one thing, my lord? In service jurisprudence, my lord, the intervention of the court is of two types, primary and secondary. In primary case, when there is a discriminatory act alleged is discriminatory, then, my lord, the act of the court is primary. When it is not discriminatory or arbitrary, perhaps in this case, my lord, then the role of the High Court is secondary. In this secondary case, my lord, the Ordnance-Body rules is to be applied. Ordnance-Body rules is reasonableness of the action, whether the action is backed by any law or not, whether the action is based upon certain evidence or not. That is the thing. So those has been reiterated here, my lord.
All right. Thank you, Mr. Verma. Yes, you.
Lordship, much has been said about charge 4. Lordship, I have to amplify on that. Lordship,
You have not challenged that, Mr. Chakravarti.
no, because I was acquitted. It was quashed, it was in my favor. But
Yes.
since he has said something, I require
Yes.
rejoinder.
Yes.
Lordship, in charge number 4, during the inquiry, it was seen what was material. Material was that the end use of the product. Loan has been given for certain reasons. A particular product had to be utilized, and whether the end use of the product was clear or not. Now, in every case, Lordship, in all 17 cases, the inquiry officer held, and it is here on.
Oh, no. You gave the loan, the borrower adjusted his another loan in the bank.
Lordship,
So
kindly.
the end use was recovery, taking money from one scheme and giving it back for the defaulted amount.
Lordship kindly sees, here it is given what happened with all the details and the shots and the affidavits and also the pictures. When these units were set up, all the photographs have also been given. So in every case, in all these 17 cases, it has been shown that there has been end use of the product with proper photographs, that the unit has been set up, which is all on record. I'm not saying anything outside record. Now, Lordship, it is quite proper that the matter may go up to the disciplinary authority and the appellate authority. Now, when the matter went up to the disciplinary authority, before that, the appellant had written a letter to the disciplinary authority that these were the charges against me and these are the findings of the inquiry authority. So please exonerate me from that partial charge number 1, which was given, which was held against me. Partial, that yes, the amount has gone in his wife's account. The other charges I was acquitted. So this
No, by the inquiry authority.
inquiry authority.
Inquiry authority held in your favor in respect of charge 4.
Yes, it is here. I'll place it. Page 580 onwards. Page 580 onwards. Lordship will take the typed page because maybe it is a bit hazy.
Page 580.
Yes. Or even the earlier page, 79, 579.
No, you tell us now. Why the inquiry of authority You showed us that page na, that partly proved or something.
I will just
Inquiry
state,
report 376.
I will just state, 579 onwards, I'll
Why
just,
you are coming to inquiry authority report is at page 376.
it is the same thing.
তাহলে you referred to 376, stick to that.
Yes.
We are already dealing
Yes,
with five papers.
it is a verbatim copy, yes, Lordship. Now, here, charge number 4, page 377, it starts from there. Page 378. After detailed reasoning,
Where did you showed us that charge 1 is partially proved?
I'm first dealing with the inquiry authority, Lordship. Charge number 4, page 377,
Is not proved. Whole charge partially proved.
page 378
Whole
is,
charge
Lordship kindly comes, page 378.
yes.
After narrating the facts, I hold the observations on the above narrated facts, the charge is not proved.
This
Item
is
2,
item 2.
charge is not proved.
Hmm.
Item 3,
What happened to 1? Page 377, not proved.
no, that ends in page 378, not proved.
Not proved.
Charge 2, not proved. Charge 3, page 379,
Not proved.
not proved. Charge 4, not proved. Same page. Charge 5, next page. I hold the observation the above the narrated facts, the charge is not proved. Page 380. Para 6.
তো স্কিমের আন্ডারে যে প্রকল্প এই যে আমাদের যেমন সূর্য সাথী অমৃত সাথী হচ্ছে না, এগুলো তো ডিসকাশন পে করার দেবে, দেবো কি দেবো না?
thing where it is said not proved, it is not on the basis of mere conjecture. Kindly see para 6. On the second para 6.
Mr. Chakraborty, what Mr. Bormon has said.
No, I agree,
No,
but
no,
here,
we cannot go into
no,
that.
no, but here the
It's not a case of no evidence.
management is itself saying,
But
management,
this is inquiry authority. Thereafter disciplinary, thereafter appellate, thereafter high court.
now lordship, when here all the
We
charges,
will not allow you to argue on that because your appeal is not that. In reply, we are hearing it.
yes, because it has been quashed. So in reply, I'm saying this, that in every case, the inquiry authority is quoting the management. He is not deciding on his own. The very second para, management has said such and such. That is in my favor.
Which one you are showing?
Every para, kindly see para 6, second para. On this charge, management has produced.
Yes, management has to produce.
He has produced.
Huh.
And from that, it is evident that there has been no irregularity. He says not
Come to
proved.
the corresponding view of the disciplinary authority.
Now, when I wrote to the disciplinary authority, what is the procedure? The procedure is that he will have to say that these are the points where I do not agree and these are the reasons. And if necessary, he will give me an opportunity of hearing. Otherwise, it will be remanded back to the inquiry authority with the directions that you proceed in this fashion. That is normally what happens. That was not done. And he proceeded on his own to say, if I take that point, he proceeded on his own to say, no, I don't agree here. No, I don't agree here. And he gave his own points without giving me an opportunity. Now, here, Lordship.
That point was not argued by you.
No, but this is the first time that it has been challenged by my learned friend.
What did you do in the writ court?
But there, Lordship, it was squashed anyway. Because
You will not argue that.
I'm saying, my Lord,
Your argument is on a separate law point. If the disciplinary authority disagrees with the finding of the inquiry authority, then he should be giving an opportunity to you to reply.
But that is, Lordship, that is on the basis of Supreme Court decision. So that is the law of the land. So I can even, Lordship, may I present this?
No, that
2021
is well settled.
No, this is the latest, Lordship, absolutely latest. It is well settled that when the inquiry officer is not the disciplinary authority, on receiving the report of inquiry, the disciplinary authority may or may not agree with the findings recorded by the former. In case of disagreement, the disciplinary authority has to record the reasons.
From ECL.
Yes. This is the latest, Lordship. SBI versus Ajay Kumar Srivastava. So, so now, Lordship, in every case, the inquiry authority said it is not proved. Now, the end use of the product, if the end use of the product is guaranteed, where is the offense? Point 1. Point 2 is, one point has been repeatedly harped on, that is, that you have disbursed the loan very quickly in one shot. Now, to that, the inquiry authority says that perhaps a gradual phasing would have been better, perhaps, but the end use of the loan has been guaranteed. Saying so, the Honorable Judge has also said that it is not only a question of the presenting officer not being prepared himself. If the presenting officer is not being prepared himself and there's no fresh evidence, there's no fresh examination, then how can these radical decisions be arrived at? Even the Honorable Judge has said this. Now, in this case, in every case,
then we will send you back to the inquiry authority.
Lordship, if
that is your argument.
No, I'm not saying that. I'm saying the end result has been guaranteed. The end result has been guaranteed.
All right, Mr. Chakraborty.
Lordship, just one more point. This is with respect to point number 1, your Lordship said that I have to hear him first. Now, there, in their own banking transaction, it has been clearly shown, I have it here in his paper book, that on 5th January 2015, the amount was transferred to the branch manager's wife. And there's a receipt. Now, on affidavit, the man said, yes, I've got the money. That's on affidavit. Otherwise, he'd be guilty of perjury. No question of hanky
No,
panky.
that Mr. Bormon has not said.
No, he says that
He has not said that I have not got the money. He has said
I've
we were
understood.
in the dark.
I've understood.
One day the borrower comes and writes a letter.
But it was no. What I'm saying is the entire transaction took place on one day. On the 5th of January, she took the money. On the 5th of January, it was disbursed to the
All right, Mr. Chok.
and Lordship, there is one point that I've taken in the appeal, and that's a very important point. That there's a system called CBS, that is core banking solution. This core banking solution, I've taken the point in the memo. That is, no one person can operate any account independently. There has to be another person who is there to ensure that the account is being operated properly. But nobody else has
Core
been
banking.
core banking solution, CBS. So it is there in the
Core.
CORE, core banking
Huh.
solution, S. Core banking solution system, no one person can operate. There's another person has to be taken in the loop, and he has to know.
We will send you back to the inquiry authority. We will
Lordship,
confirm
after
the
10
order.
years,
taken up,
Lordship,
The more you argue on that point, you more become vulnerable, Mr. Chakraborty.
Lordship, my lord has also said, he has referred to that case also, that if the case is, the verdict is so disproportionate that it shocks the conscience of the court.
That we have considered, could have considered, but that way my lord did not go.
No,
My
that
lord
is,
went on another aspect that no, you are a bad person, you have misappropriated. But I'm not giving dismissal. I am seeing 25,000 was the amount. Minor penalty.
yes, but which I have, Lordship, I have
that you cannot do
repudiated.
without challenging the order. You ought to have challenged the order. That how upon arriving at that is the argument. That you could have said that the punishment is disproportionate.
I said so in the trial court.
But the court did not. Court established that you are a bad person.
And entire thing is due to a technical violation. So, Lordship, I stick to that point that the entire thing is due to a technical violation.
Only one line, my lord. So far, the allegation of my learned senior friend is this: once the disciplinary authority disagrees, he was not allowed an opportunity. It is not so, my lord, because after the
Is that
inquiry, authority order was passed, then we framed the preliminary charges, and again we sought for his reply, and his reply has been given
Before
There are-
the IA.
before the disciplinary authority, my lord. Before disciplinary authority comes to a finding of, my lord, this proof or not proving the charges, he was given an opportunity, and he
Where
sent
do
his
we find
reply.
that?
My lord, it is, my lord, our preliminary finding is at page number 310 to 317 of our paper book, my lord.
No, that is whose finding?
My lord, after the inquiry report came,
Huh?
the disciplinary authority disagrees, and we came to a preliminary finding and sent to the, my lord, the appellant.
Oh, disciplinary authority
Disciplinary
arrived
authority,
at a
and sought for
preliminary.
his reply. Sought for his reply. Reply came thereafter, my lord, that conclusive, my lord, finding came.
Here, Lordship,
Two findings were there.
what happened was I had written a letter stating that charge number 1, kindly exonerate me. That was the letter. And in response to that letter, what would have been the course of action? The course of action would have been that, okay, we are sending it back there, or you come and you will be given an opportunity of hearing. Now, on the basis of that letter, Lordship, the case went forward, and he said that this 25,000 which was given has no connection with the
Where you given an
misappropriation.
opportunity to reply.
Yes, my lord, it is there, my lord. Dates are there, my lord.
That is where do we find that?
My lord, from my lord paper book, kindly, my lord. 308 to 309, my lord. First, my lord, against the inquiry
Mr.
report.
Bormon, we are going on the basis of their paper. Your paper book is how many volumes?
2 volumes only, my
আসেনি?
নেই, এখানে নেই।
No, this is, I am saying that this has been done by the inquiry authority. So kindly exonerate me.
I am coming. Kindly bear with me. I am coming. Your letter.
That is the letter.
And so far CDS, my lord, the CDS point is there, my lord. That point was never taken up in his, my lord.
show it to him, he can say which page is of the.
Corresponding paper book.
No, what he is showing is, okay,
May I, my lord? First, the inquiry report came.
Hmm.
Once it was communicated to him, he gave a reply.
Hmm.
That is reply is, my lord, dated 8th of February 2016. That is reply to the inquiry report. Thereafter, my lord, the DA made a preliminary finding.
but
Dated,
how?
my lord, may I, my lord, first? DA made a preliminary finding dated 18th of February 2016 and communicated to him. In respect thereof, my lord, he again gave a reply dated 3rd March 2016 at page 318. Thereafter, my lord, after getting this reply,
3rd March 2016.
16.
Hmm.
That
So-
is at page number 308. Thereafter, my lord, the DA came to that finding, my lord, the final finding. And thereafter, again, his
So-
reply, again appeal, again, my lord, to High Court order. It's not that, my lord,
No, so,
immediately after inquiry report, we came to a conclusive finding. Before
No.
that, my lord, we made a preliminary finding and sought for
What
his-
was the preliminary finding? Disagreeing with the
yes,
inquiry or?
yes,
Yeah,
yes.
this ex-
But for
this ex-
that, I was not
ex-
summoned. For
The
that, I was
disagreement
not
gave an
given an
opportunity.
opportunity.
That you filed the reply, to that you
He
filed.
filed-
That
Yes,
was
yes.
later. That was after this report was prepared by the disciplinary authority and sent to me. Prior to that, where did I get a hearing?
After conclusion,
Yes, he sent me.
preliminary finding was there.
Preliminary finding. That
Preliminary
was
That
not
you
final.
gave a reply.
Yes, but that preliminary finding was on what
He did not
basis?
seek for any retrial or
So
any hearing.
preliminary finding is disagreement with the inquiry authority.
Yes, but Lordship, I had stated in my letter that kindly absolve me from charge 1. That was my
We are not
prayer.
concerned with that. We are wanting, you argued that the IA finding was toppled over by the DA finding, but
Yes.
I was not given an
My lord,
opportunity.
his reply was only one page. Kindly see, he was also part of.
পেয়েছে? ওর ইয়েটা পেয়েছে?
But this,
That is
but
his reply. Only, my lord, one paragraph he gave against the
where is
preliminary
this
finding. Kindly see.
preliminary? How is this preliminary?
This is his reply. He never sought for any other thing or sought for rehearing or
Preliminary কি করে হবে? এটা তো পুরোটাই আছে. This is not preliminary. This is an entire report. This is an entire report.
my lord, kindly see page. Where is the page?
Every charge was gone into and details were given. Where did I get an opportunity? This is an entire report,
Which one is entire report?
page 310 onwards.
My paper. আমারটা দিন না।
এটা ওনার পেপার।
Where is my note?
In my paper book, it is page 387. 387 in my paper.
This is your letter, 8th of February 2016.
Yes,
is it?
yes, only one point. Only one point.
Hmm?
That only one point was given.
This was in reply to the DA letter.
No, this was not in reply to any letter. This was after the.
Submissions on the findings of the inquiry officer. No. What you are saying, Mr. Varman?
My
This is his reply to the inquiry report.
That is what I'm saying. And it was an entire report, no question of
And
preliminary.
18 to 2006, this is a preliminary report.
No, entire.
18 to 2006 because my lord, DA finding is dated 6th of
18th
April
of February 2016.
This is the entire report
This is the final order passed by the disciplinary authority.
without listening to,
Preliminary.
without hearing.
Thereafter, my lord, again his reply was sought for it. Again, my lord, final report. Final.
Maybe his argument is not it. He said that when the DA is not agreeing with IA
So this
and is enhancing the punishment,
that is
then
why, my
you
lord, that is why you sought for his reply. His reply came. Thereafter, my lord, we came to
where reply? Where is your preliminary? This is 8th of February to 18th February
18th of February
26.
2016, my lord. It is
18th of February. is the
18th of February
that
2016.
is your final order.
Thereafter, it is not the though it is, my lord, the findings are because same. It was basically the finding was same. So it was basically was meant to while seeking a reply that this is the, my lord, the order that is coming in your way. So you please give your reply. Then his reply came. Thereafter, my lord, we gave because the final order is dated, my lord, 6th of April 2016.
89,
He has ordered
18th of February 26th. এইটার পরে ডিএটা করে ও একটা
There are, yes,
paragraph
my lord,
বলে
the order,
But-
final order is on 6th of April, my lord. 6th of April 2016, that is the final order. Maybe we have not captioned like this ki preliminary charges, but that was the communication made to him for the purpose of seeking his mother reply. The final order is 6th of April 2016.
All right, thank you.
Deeply obliged, my lord.
Learned
obliged,
advocates appearing for the respective parties. দুটোতে একসাথে অর্ডার দিব। Have concluded.
My lord, one decision was not with me that the discipline authority can disagree with the inquiry authority. May I submit tomorrow?
No, that is disagreement always can, provided he should be given an
Yes,
opportunity.
that is there. Extremely grateful, my lord.
Next matter,
Next one.
tomorrow,
Do we dismiss or we allow?
as your worship pleases.
Then we can dismiss and rise. What is the problem?